but that's fine. It's no problem. This is the first panel, officially, since we had this wonderful opening colloquium, which started us off quite heatedly, actually. I didn't expect it to be as engaged as it was, but it was quite engaged. So this panel is the Antiquity Panel, and that was kind of intentional in terms of how we structured the workshop, which I will explain when I give my commentary. And our first speaker, again, we're always going to let our host speak first. So our first speaker is Guido Pfeifer. Guido.
Thank you very much.
Oh, you have a handout too?
A handout?
Oh, I could have made the copies for you.
Yeah.
These are in color. This makes us look bad. I did the black and white thing.
Okay. It's all about status right now.
Yeah. Color is important.
So, justice and legal decision-making, aspects of the judicial cultures of the ancient Near East. The records of ancient Near Eastern cuneiform law show manifold aspects of an early but elaborated judicial culture. Some of the earliest ever written records in the history of law are concerning the resolution of disputes between private parties. From the Neo-Sumerian or U3 period, we know a specially styled form of court documents marked with the note ditilla. This is Sumerian for closed case. The subsequent Old Babylonian period of the first 4 centuries of the second millennium before Common Era is the one covering the greatest amount of documentary material from legal practice, including the documentation of legal disputes and judicial rulings, but also the most prominent law collections, the so-called Laws of Hammurabi. The structure and the literary composition of the Laws of Hammurabi share an obvious tradition with older law collections, namely the Laws of Ur-Namma from Ur and the Laws of Lipit Ishtar from Isin in Sumerian, as well as the so-called Laws of Eshnunna in Akkadian. But Hammurabi's laws are the only ones which were delivered by original and official texts and not only in private copies. And there is yet another category of texts which deserves our attention, the so-called lexical lists, such as Hubulu and Anaitishu, which combine legal terms and phrases in Sumerian and Akkadian and were used in the curriculum of scribal schools. Besides from these sources, we can draw information also from other documents, as private letters or the correspondence between rulers and their officials. Even though the ancient Near Eastern history shows an enormous quantity and variety of ethnic groups and political entities up to the second half of the first millennium before Common Era, we can observe a rather stable literary legal tradition until the first century of Common Era, which gives a testimony of legal institutions and of legal cultures which share more or less common features. Asking for the organization of jurisdiction, we seem to find not little information. The king served as the highest judicial power. However, he also delegated decisions to his officials. The administration of justice at a local level was generally carried out by committees of judges comprising approximately 3 to 10 judges, dayanu, or less commonly by individual judges. The mayor, rabianum, the elders, shibutum, the assembly, puchum, and the merchants' guilds, carum, were involved in the decisions, as well as other institutions such as the town, alum, the citizens, avilu, or the neighborhood, babtum, and, to a limited extent, the jurisdiction of temples. With regard to these findings alone, we could think of a multitude of jurisdictions and consider in which way or the other they were overlapping. Unfortunately, many questions have to be left unanswered. Apart from the fact that disputes in the context of public tenure, feud, seem to have been reserved for the king and his officials, there is no indication for differentiated competences with regard to the matters of fact of a case. Furthermore, we are unable to discover from the written records why and when further groups, apart from judges in the narrower sense of the word, were involved in the process. It appears that there was no specific professional training or qualification to become a judge. The same unsatisfactory result holds true for the details of the procedure of lawsuits. Usually, documents of legal disputes report the names of the parties, the names of the judges, and the scribe. They tell us about the matters of facts, claim and defense, the means of evidence brought before the judges, mostly witnesses, documents, and assertory oath, and the judgment as such, often combined with a promissory oath by one or both of the parties. But we have almost no knowledge about the way in which judgments were reached, because there are no traces of reasoning or motivation in the documents, not to speak of citation of laws or rules, which lacks completely. And outmost information can be found in extremely seldom hints that the judges deliberated on the case, but not anything beyond the mere fact of deliberation. We do not know about the time frame within judgments were reached, nor are there hardly any records describing their enforcement. Obviously, all these, from our point of view, essential information were not considered worth to be documented. And, as a matter of fact, they were not, because the main purpose of those records was to prove the core of agreements, settlements, or judgments, but not their context. Thus, we are unable to acquire detailed understanding of jurisdiction and its organization, at least in a manner we are used to, despite the fact that the institutions in charge with jurisdiction and their decisions are mentioned as such in written records. We can only make out the shadowy outline of legal decision-making and flesh it out with our own suppositions and speculative assumptions. By doing so, we are projecting our own ideas onto the written records, namely how jurisdiction is organized and put into effect. Ultimately, our very methodology of putting questions to the records is probably the reason for unsatisfactory results in our analysis of the sources. At this point, the idea of going even a step further and ask for a juridical system of decision-making seems presumptuous. An approach with lower expectations could possibly offer greater success. If we risk an open-minded glance at the textual material, a truth becomes at once apparent, which probably appears quite banal, one that cannot, however, be taken for granted in the context of the above-mentioned background of disparate organizational structures. The Old Babylonian language, for example, with the word dayanum, has already a term of its own for a judge. Etymologically, it is closely related to the verb dianum, which itself has the meaning of deciding, and deciding a legal matter. Of particular significance is that this term represents distinct specialist terminology, inasmuch as the terms may be used in other non-legal contexts, but if so, they always seem to imply an allusion to legal decision-making. I will come back to this in a few moments. At any rate, the terms can be contrasted to other terminology which also occurs in everyday language. For example, the verb parasum, to cut off, to separate, and to decide. However, the development of a specific legal terminology can be evaluated as one first step of the comprehension of law as a subject or a discipline. This impression becomes even more intense if we take a closer look to the normative parts of the law collections, especially the laws of Hammurabi, with a total of 282 rules, sections, or paragraphs. Their greater number shows a typical linguistic structure of a conditional clause containing the matters of fact and a main clause presenting the legal consequences. You see this with the example of paragraph 5 of the Laws of Hammurabi on the handout. This if-then structure is not exclusively applied on legal rules, but is also familiar in the context of other technical or, let's say, scientific texts, such as omina, predicting the future, or medical or mathematical texts. On a general level, the linguistic styling of such specialized texts can be understood as a kind of processing of data. If this approach is a mere technical one, or if it marks the birth of science, is not our topic today, but an aspect dealt with in another workshop on law and mathematics in ancient Egypt and Mesopotamia that will take place in Frankfurt at the beginning of February. Anyway, specific terminology and linguistic structure imply a strong impact of the scribal schools, where not only the technique of cuneiform writing was taught, but, of course, also the substantial content of the subjects and disciplines which were preserved and delivered by the media of clay tablets and inscriptions. Returning to the law collections in general, and in particular to the laws of Hammurabi, the question is obvious if its 282 paragraphs are arranged in a special way, and many scholars tried to depict a systematic order of the law code, more or less successfully. Among the patterns that can be identified is a clustering of legal rules to some extent. We find groups of sections that refer to rather public affairs, such as food, and others that concern private business. Sanctions that rely on delict and are differentiated from those which base on contract. Therefore, Herbert Pechow, who was probably the most outstanding legal scholar in the field of cuneiform law, recognized a, I quote, juridical theoretical reflection and a juridical dogmatic conceptual thinking as a background of the laws. At the same time, there is no doubt that the content of the law code is fragmentary because it lacks some institutions which are testified very well by the documents of legal practice, for example, surety. Self-evident rules, such as simple theft, are not mentioned at all in favor of specific qualifications, for example, theft from a temple or from the palace, a fact which is commonly explained by a background of understood customary law. In addition, the elaborated casuistic style of the sections indicates that the redactors intended rather a reform act than a general legislation. However, the laws in no way come up to the requirements of a modern systematical codification. With regard to criteria as coherence and consistency, though, we can assume that the law collection was intended to be applied. At least the epilogue to the Laws of Hammurabi reports that the stela was presented in the main temple of Babylon and that the king addresses the citizen bringing a claim with the words, I quote, "Let the wronged man who has a lawsuit go before my statue called King of Justice, and then have the inscription on my monument read out and hear my precious words, that my monument may make clear his lawsuit to him, let him see the law which applies to him, and let his heart be set at ease. Again, unfortunately, Hammurabi does not tell us how the laws are applied in court and by the judges. Needless to mention that the procedure as described in the epilogue is not testified in the records. The mentioned title, King of Justice, leads finally to another aspect. Overlapping systems of decision-making as an epistemic model is not restricted to a concept of jurisdiction, but can be understood in a wider sense, especially because the textual records refer as well to a social as to a political and a religious context. In this perspective, it becomes clear that decision-making is virtually fundamental to the understanding of justice, not only during the Old Babylonian period. The act of deciding the legal dispute represents the central category in terms of the tasks performed by the judge. This finding is supported by the fact that deviant behavior by the ruling judge is sanctioned in paragraph 5 of the Code of Hammurabi. I quote from the handout. If a judge renders a judgment, gives a verdict, or deposits a sealed opinion, after which he reverses his judgment, they shall charge and convict that judge of having reversed the judgment which he rendered, and he shall give 12-fold the claim of that judgment. Moreover, they shall unseat him from his judgeship in the assembly, and he shall never again sit in judgment with the judges. Alongside the specific preventative aspect of the sanction, it is also the authority of judicial judgment as such which is protected here. Incidentally, apart from the elements concerning defamation in the paragraphs 1 to 4 of Hammurabi's legal code, this regulation is the only provision with a clear reference to court proceedings. The connection between decision-making and justice recurs, however, to some extent on a political level in the context of the way the ruler presented himself and the style of his legislation. Thus, the epilogue of Hammurabi's laws commences by calling the previous normative component of the text, the, I quote, just decisions, the dinat misharim, you could also translate the decisions of justice, which Hammurabi, the able king, has established and thereby has directed the land along the course of truth and the correct way of life. Here, as in other sections of the prologue and epilogue, a very specific model for the figure of the ruler is revealed. The king carries out the task of directing the state as if he were a judge, but actually represents at the same time the highest secular judicial authority. This model can also be found immortalized in the Old Babylonian pantheon, which displays a selection of judicial deities, most important of all, however, the sun god Shamash as the highest patron of law and the most important divine judge. His significance, as well as the close connection between the divine and the human, especially in the fields of governance and law, is perhaps most apparent through the portrayal on the front of the stela with the Code of Hammurabi, in which the king receives from Shamash the ruling insignia of a ring and scepter whilst praying to the god on his throne. Thus, he is charged with the task to install justice within the land and, at the same time, legitimized to do so by ruling the country, legislation included. Both aspects are also described in detail in the text of the prologue of the laws. These are just a few examples taken from one text, the Laws of Hammurabi. The number can easily be multiplied if we consider further texts, for example, consecration inscriptions of buildings or official state treaties. But it seems quite clear how the concept or let's say the normativity of justice, is taken from both a political and a metaphysical level and implemented into the legal context. This phenomenon becomes even more relevant if we remember that justice is primarily understood as social justice. We only have to think of the protection of widows and orphans as a paradigm, or the practice of debt release. At the same time, we can observe that the legal, or rather jurisdictional aspect of justice itself is transferred to the political and metaphysical dimension. Therefore, it might seem more adequate to speak of interference rather than of implementation. Let me come to some brief conclusions. The sources of ancient Near Eastern legal history indicate a multitude of different jurisdictions, in the sense that we find a great number of institutions which were in charge of dispute resolution, regardless of its official or private character, an aspect we have not discussed at all. However, the details of legal decision-making, which might seem interesting from a modern point of view, remain hidden from our eyes. The development of a specific legal terminology, the linguistic technique, and the traces of a systematic approach, particularly in the law collections, imply a background of a conceptual legal thinking, even though this might not come up with a modern understanding of a juridical system. Correct and just decision-making is portrayed in the sources as a universal principle, which is transformed from several, also transcendental dimensions to another. At the same time, these dimensions or systems cannot be separated from each other, but are overlapping, or rather interfering, in a sense that they are referring to each other with a lasting influence on the way of life and of thinking of the ancient Near East. Thank you very much.